welcome everyone. Thank you for joining us today as we talk about this intersection of trademark law and artificial intelligence. I am Amanda Compton. I am an instructor here at Scalia Law School. My background is in trademark law and written in the area of non-traditional trademark law specifically. The AI piece has escaped me a little bit, so I'm happy to be a part of this panel so I can also learn from our esteemed panelists and the experts, true experts in this field. Our panelists today are going to take a deeper look at the intersection of AI and trademark and trademark law, and specifically our panelists will address how artificial intelligence will or has already impacted trademark law, the rights of intellectual property owners and how those rights might shift now or in the future, and how AI should or will shape how consumers will interact with brands. So we thank you for joining us on what I think is going to be a lively discussion. Before we begin, I do want to take a moment to introduce our panelists. I'll start with Professor Sonia Katyal, who is the Haas Distinguished Chair at the University of California, Berkeley School of Law and is the co-director for the Berkeley Center for Law and Technology. Professor Katyal's work focuses primarily on the intersection of technology, intellectual property, and civil rights. And her current projects include the look at artificial intelligence and intellectual property and trademark law and branding. Next, we have Dr. Anka Moreland, who is an associate professor of intellectual property and I'm going to butcher this name, so please correct me later on, at Maastricht University in the Netherlands. Her research during the last 2 years has mainly focused on the interface between trademarks and new technologies. She has published a paper on how AI technologies are used in assessing trademarks by trademark offices and judges in various jurisdictions. And then more from a right holder perspective, she also discusses trademark use in virtual and augmented realities. Her most recent paper is on the role of trademarks, or on the role that trademarks still play in online shopping and where consumers are assisted by AI technologies. Next, we have Josh Simmons. He's an intellectual property litigation partner in the Kirkland Ellis, New York office. He has been involved in a number of cutting-edge copyright and trademark litigations. Of particular relevance to this panel, Josh has litigated several cases involving artificial intelligence and IP, including the AAP's litigation against Audible's AI-based Audible captions feature and Thomas Reuter's case against Ross Intelligence. He also chairs the 2022 Second Circle Judicial Conference Artificial Intelligence Subcommittee. And finally, but not least, we have Matt Stratton, who is the Associate General Counsel and Director at Snap Inc., the company behind Snapchat. Snapchat is a leading communications media and augmented reality platform used by over 290 million people each day, including my own children and myself. Matt has worked at Snap since 2016 and currently leads the intellectual property team in legal. They handle all trademarks, copyright, patent prosecution, and open source software issues. Previously, Matt was Associate General Counsel of IP at Facebook and was responsible for a number of its main brands, as well as asset licensing. And earlier, he worked at Harvey Skidskin LLP and Hanson Bridget LLP, both law firms in San Francisco, doing all things trademark and copyright. He lives in Manhattan Beach, California, with his wife and his 2 daughters. So thank you for joining us today, panelists. I'm hearing the participants clapping their hands far off into the distance in our own reality here on Zoom. So again, let's first, I think it might make a lot of sense for some of our participants. Perhaps Sonia and Anka could help us start off by going over some basic tenets of trademark law, maybe both from the US and EU perspective, and how you see artificial intelligence impacting that.
Great, thank you so much, Amanda. It's just such a pleasure to see you and to see this list of panelists and attendees. I know that it would be better if we were all together in person, but I have to just thank you guys so much for organizing this incredible conference in celebration of Ryan's work and the book, and just really thinking about the intersections between AI and IP is something that I just find to be an incredibly fascinating intersection. So it's great to be here. Thanks so much. And I want to start just by kind of introducing our topic for those of you who are less familiar with trademark law. Trademark law typically protects brands and logos and other trade symbols that identify the source of products in our marketplace. And so what we've planned to do is kind of start off in this panel by each of us just saying a few very brief kind of introductory words, and then we can open things up for a broader discussion. So my comments are going to be very brief. But I want to start off by just talking a little bit about the dominant economic theory behind the protection of trademark law, because I think it's deeply relevant to thinking about AI. So the dominant economic theory justifying protection for trademarks is that trademark law protection plays the function of lowering consumer search costs in the marketplace. And so rather than having to inquire into the source and the qualities of every potential purchase, the consumer is able to save time and efficiency by instead looking to trademarks as shorthand indicators of both source and quality. And that this function in the law has helped to kind of maintain the quality of a trademark because consumers associate a brand with a particular identity as well as a particular quality. But this theory, and so far, kind of all of the search cost theory of trademarks is really consumer-based in nature. And there's a vast literature that also details the risk of trademark dilution to the consumer by increasing search costs. And these harms, I think, are really characterized as harms to the consumer, and they kind of stem from risks to the marketplace that emerge after the trademark is established. Now, all of the literature focuses on trademarks from the perspective of kind of a vertical division between trademark applicants and registrants and the consumer. Now, what I have argued in a piece with Aniket Kasari that was published in the Berkeley Tech Law Journal is that we actually believe that the increasing role of artificial intelligence and machine learning does something really important. And it reverses this dynamic and actually potentially transforms the trademark applicant into a consumer. Now, why do we say this? Well, rather than thinking about kind of a product-driven marketplace, we actually think that AI forces us to consider the economics of a language-driven marketplace, a sort of identity symbol-driven marketplace. So if we think about this in the context of marketing and AI with respect to the consumer, we see that AI has already had a transformative effect in several areas. So search, recommendation engines, programmatic advertising, marketing forecasting, speech, text recognition, natural language, like all of these things are happening in the body of AI-driven developments to serve the consumer in the marketplace. But in the area of trademarks, what I see happening is a very similar kind of transformation where search and suggestion tools get ultimately transformed by AI, offering us kind of a new economy for trademark search applicants in terms of studying the availability of marks that can be registered and transforming trademark applicants into consumers of kind of AI-driven suggestions in the process. And so what this does, I think, is AI allows us to revolutionize the process of search and registration for firms. And it requires us, I think, to really think about this kind of conventional analysis regarding search costs. But here we should think about search costs with respect to trademark firms themselves. So what are some ways that we might think about how AI can revolutionize trademark law? And here I'm thinking about the kind of trademark firm in particular, because I know that later panelists are going to talk about AI and trademarks' effect on the consumer. But what are some ways in which AI is going to affect trademark firms, trademark registrants? So some possible uses that I've already outlined involve the improvement of search, suggestion alternatives for those that are seeking trademarks, better speech recognition for sound marks, better optimal ways of actually engaging in comparisons of substantial similarity. AI can aid in image creation, actually potentially drawing particular logos and suggestions for future applicants. It can create suggestion tools, as we've already seen, in terms of how it interacts with consumers. And it can also really aid in the process of trademark valuation internationally. And so these are just some of the ways in which AI is going to revolutionize the landscape of trademark law. And also, I should say, revolutionize the way that governments can interact with the registration of trademarks as well at the USPTO level in the US and elsewhere internationally. So in the end, I would say that the advent of AI is going to have dramatic effects on the role of trademark search. It's going to have dramatic effects on clearance, selection, registration, enforcement. Every aspect of the trademark ecosystem is going to be revolutionized by the role of AI. And in the process, I think it's going to open up interesting possibilities for the way in which the law should approach trademark law, particularly in terms of rethinking search costs in the future. Thanks so much.
So thank you, Amanda. I'm just taking the word. You may not see me. I had troubles with the video, but nevertheless, greetings from Maastricht, the Netherlands. I'm really happy. Maastricht is the right term. So Amanda, you did very well. I'm very happy to be here because I'm going to shed a bit of light about some EU law concepts, but I think also generally what role trademarks play in AI-assisted online shopping environments. That would be my first point I want to say some things about. And in a second part on how an AI-assisted consumer actually now makes purchasing choices. So let's start with trademark functions. Sonia already started by saying that trademarks are a shorthand indicator. They lower search costs for consumers on the market, and thereby they make purchasing more simple and more effective. And that is useful for the market to keep. Now, the second function I've identified is also to guarantee fair competition so that competitors cannot interfere in the communication between a brand and consumers. And on top of that, we have these accessory functions where actually brand images convey feelings and values to consumers, which again helps them to make choices that are most in line with what they want. Now, are these functions still needed when we have AI that has enhanced capacity and can make a lot of searches very much quicker than any human can right now? So maybe not for a speedy and effective purchasing experience, we will need trademarks. But I argue that where consumers are still involved in purchases, and even with automated ordering, consumers will in the end consume the product. Then it still matters for their preference formation, what they see, what they feel, and what they hear when they are consuming the product. And this is particularly so for brands that convey these positive feelings, like reputed marks, which AI suggestions cannot, we argue. It really has to be the product with the trademark that can do that. And it's not the recommendations that will have that effect. So when this then feeds back into the next purchasing decisions, we argue that this function is still useful to have. Also for competition, it would be distorted if trademarks are not protected anymore in an AI world, because competitors could just provide confusing information. And there is a need for this even where AI technology can identify confusing products, which I'm yet not sure whether really AI will identify counterfeit products in every situation in a reliable way. But that is to be seen. My second point in the paper is that of the AI-assisted consumer. As Sonia already said, trademark law heavily relies on the perception of the consumer. So for whether a mark is distinctive, so whether it conveys in an origin, but also for whether a consumer is likely to be confused between a sign and a mark. And we know that consumers perceive things and behave in at least two ways. There are either unconscious, rapid, or automatic decisions that they make. That is particularly for common activities, things in the background where not much attention is needed. And then for things that are unusual or new, there will be more conscious, slow, and deliberate manner of dealing with these things. Now, the question then is, how do consumers behave when they are purchasing with different tools of AI? Will they have a high or a low level of attentiveness? We say it depends on the type of products and services, as that always has been, but also, and that is the trust in the AI technology. We have heard that yesterday also from Susan Hallen, that is very important. If consumers can trust how the AI works, they may actually accept these choices without or with less attentiveness than they would do if they don't trust it that much. And of course, we need more behavioral data on how consumers are actually behaving in product recommendation, in automatic ordering, in chatbots, in virtual assistants. So in my paper, I try to suggest on how consumers behave with different AI tools on a spectrum between low and strong involvement in the purchasing process. And I look at product recommendations that are arguably still leaving more space to the consumer to still make choices when they are offered different recommendations with detailed information. It is still the consumer that in the end will have to make a decision. So there is still involvement by the human consumer. Whereas with virtual assistants and automatic ordering, there is less of an involvement. Only the final decision, or sometimes not even that, will be taken by the consumer. That may be similar to professional advice. When you buy a house, you also will rely heavily on what the person qualified in this sector will tell you. And mostly you will take over that advice if you trust that this person is doing a good job and has your best preferences, interests in mind. And in an AI context, one would have to also suggest that bias needs to be lowered to the extent that their negative outcome will be limited. So, and if that is accepted, then we can maybe see human consumers becoming less involved. Shortly, just finishing, in the end, I believe it is going to be a case-by-case assessment when we are really going into the details of which consumer makes which choices with which AI tools. And the EU legal concept for an average consumer at least seems to be flexible enough to be able to do so. So these were the two short points at this point, Amanda. I'm happy to go into things later on if that's valued.
Thank you. Josh, you're up next.
Well, thank you. And it's great to be here. I'm sort of listening to Sonia and Anka, and it's interesting. As someone who litigates these cases, in some ways, I think it's the same law is going to be applied regardless of the use of artificial intelligence. I used to say with social media, it was the same law, different wrapper. And in some ways, I think that same aphorism may apply to AI. We've dealt with in trademark law technological changes before, or changes in purchasing behavior. You can imagine people going from like the local store to a department store or catalog to the internet to direct sales on social media. And trademark law is very adaptable because it's all about consumer perception. And that means that context remains key, and we can adapt to those situations. The growth of the AI in that process may create some changes, but from my perspective, I think we will be able to use the existing laws fairly effectively. For example, if you consider AI from two different perspectives. So on the one hand, AI, may be happening within the black box of the platform or other, program that you're interacting with. But what is the consumer perceiving? They're giving inputs and they're receiving outputs. We've been doing that for a long time, whether with artificial intelligence or not. And the question has always been, okay, well, you receive it, you put something in and you get something back. Is that confusing? This reminds me of the MTM versus Amazon case from the Ninth Circuit, which was decided a few years ago, where you would run a search for watches, and Amazon, instead of saying we have no watches, would say, well, here's some other watches you might like. And the Ninth Circuit eventually affirmed a summary judgment decision on that basis, saying, yeah, when you got those results back, they were clear who they were coming from, that they weren't from the trademark owner, and so there wasn't likely to be confusion. The debate in the case really was about, can you decide that as summary judgment, or should you have the jury decide it based on the evidence in the case. And the Ninth Circuit panel actually flipped on that issue, originally saying this shouldn't have been a summary judgment decision, and then evaluating that and issuing a new opinion on the subject. We have courts in the EU who've considered this as well in Cosmetic Warriors versus Amazon, which also involved the Lush products. Again, the question was, what is the consumer seeing? The courts there reached the opposite conclusion, because in that case, they found that consumers would be confused. And so, as behavior changes, there may be some changes in the facts, but ultimately, I think the law is going to end up, addressing that, whether it's, sonic searching, the auditory searching we were talking about, or this concept of automatic ordering, which again, we have had for even before we were so artificial intelligence focused, or even the idea of preference-based searching, where someone, might be getting a product without asking for that specific brand, but instead a quality of the brand, whether it's the cheapest brand or the highest rated. That is something that we've already done and can work through. I think the concern is going to be, are consumers in fact getting confused? And also, to Anka's point, the fair competition aspect, because a lot of brand owners, and certainly I think the courts, consider trademarks' origin may have been with consumer protection, but there is a intellectual property ownership component to that as well. Now, one last comment, and I'll turn it over back to Amanda. But the other piece of this puzzle is what's going on inside that box. And that's where I actually think there is some work to do, because maybe the consumer protection policies are different when we're talking about what is actually happening inside. Are you setting preferences that the consumer doesn't realize that are being set? Are there biases created by the data? Anka was mentioning counterfeit product identification. And you can imagine a world where an AI is set about to identify counterfeit products, but based on the data ends up going after a specific class of products, regardless of their counterfeit nature, because of the nature of the data that's being consumed. And so I think those concerns will be interesting. The question is that a trademark issue, or does that come under a different rubric, whether it be antitrust, which has been suggested by some, or some other regulatory agency approach? The FTC, for example, has much broader authority when it comes to those issues. So I look forward to the panel. I think ultimately, from a litigator's perspective, I think we're ready and able and already litigating these issues. And I'll be curious to see sort of where the conversation goes from here.
Thank you, Josh. Matt?
Hi, everyone. My name is Matt Stratton. I'm at Snapchat, and I head the IP team there. And I just wanted to, first of all, thank everyone for the opportunity to join this panel. I think it's going to be a really exciting morning here, or afternoon, I guess, for most of you. And so let me just share a little bit of a different perspective. And this is just one that's a little bit more product focused, and one that's, I think, looking a little bit down the road toward what tech companies are going to be doing with respect to AI, augmented reality, machine learning, and how that's going to intersect with trademarks and consumer experiences and purchasing opportunities. So AI, as the other panelists have mentioned, is very much woven in the fabric of our tech products today. We don't have to speculate about how, like, the computer in 2001 Space Odyssey or anything. I mean, this is like happening, and it's subtle for the most part, but I think it's going to become more and more obvious and more interesting as the capabilities increase. And so just from speaking about the company that I work at, Snapchat, we have AI already playing critical roles throughout our products. So for example, we have a scan product where you use your phone, the camera on your phone, and you press and hold, and there's like an automated scan function that comes and just observes what's in the environment and then suggests experiences for you to try as a user. So it might hear something and make a suggestion about an augmented reality face filter to use. It may observe that the weather is a particular, it's snowing, for example, and it's going to suggest that you apply winter-themed stickers to your photo. or maybe it observes a particular product and gives you information about that product. So scan and visual search, both by Snap and other companies that are deep into the space like Google, I think have some very, very exciting and interesting and potentially treacherous areas for brand owners and consumers. What other products that are AI powered include our augmented reality face filters and experiences that we call lenses. And these are transitioning from being kind of more traditional like animation products to true machine learning outputs. And we have some really exciting recent examples of that. For example, we have what we called the 3D cartoon lens that came out sort of the beginning of the summer. And it made you into like kind of a contemporary animated 3D figure that was a representation of how you look, but sort of a cartoon version of it. Extremely popular. Within the first week, it got something like 2.8 billion impressions and is a lot of fun to play with. But there's some other more back-end type things that AI is powering. That includes content ranking for seeing like what material and media you're going to see first in your feed. Content moderation is another one where companies like Snap try to identify content that is harmful and to weed it out or prevent its upload just by virtue of like computer vision and other AI powered factors. And then speech recognition, search, these kinds of things other panelists have already talked about. These are already powerful tools that we all have access to right now. So I think there's a couple interesting trademark issues that come with respect to machine learning in particular. And one is just the more basic concept of how do we train like a machine learning model. And just by way of a little bit of background, a machine learning model is basically a computer algorithm that you can teach to basically teach itself. And it makes for a very interesting product because you can't really predict necessarily how it's going to work. And for that reason, it can actually work very well and also give you outputs that are, that may not have occurred to you or that are super interesting or that you wouldn't be able to otherwise achieve. And so how you train it it definitely gets raises some interesting trademark issues if you're training it with branded materials or logos, for example. But I think where the future is headed is like as visual search becomes more effective and successful, and if you basically get to a point where you can point your device at any object and have it be recognized, and have the computer that operates your device therefore trigger an experience that that the object is intending to trigger, then I think we get some pretty cool trademark questions coming out of that. So for example, if you were to use a visual search product like a Google Lens or Snapchat, or I think Amazon has a shopping, like an e-commerce version as well, you point your device at something and it recognizes a soda can. Or it recognizes a truck on the street. And so perhaps that will give you information about what that object is. Okay, it's going to tell you it's a truck. I mean, I guess you know that already, or a soda can, but maybe it can give you some more information about that too. But what if, as the machine becomes more effective at recognizing objects, and it starts to include branded objects. So it's not just saying, okay, well, I know it's a soda can or a truck, but I know that it's a Coca-Cola can, or I know that it's a Ford F-150. Then you can start opening opportunities for interesting advertising, promotional type experiences, informational experiences, comparative advertising experiences. So let's just say, for example, like, and I wouldn't be surprised if this is going to be our future, because it already is our future with respect to words, is like an ecosystem of objects, kind of like the Google AdWords keyword type system we have right now, where when you do a search, the computer recognizes your word, and then there's like an ad ecosystem built around that, and a ranking and suggestion system for consumers to find out what those words, could mean both literally from an informational perspective and also from a promotional perspective. And I think if we're talking about objects and we're talking about branded objects in particular, then okay, what happens if you do a scan and you reckon your computer, your mobile device recognizes a Coke can as a Coke can? Well, then is maybe Coke wants to pay Google or whatever the platform is to trigger an experience that will promote that product because it knows you're looking at it. Okay, no big deal. Maybe annoying, maybe not. But what if a competitor? What if Pepsi says, okay, actually, I want to buy the virtual the Coke can imagery as a marker because I want to run a comparative ad against it. Like, how would Coke feel about that? We already have analogies in the keyword space, but I think when we get into objects, I think it's going to raise a lot of these issues all over again. And then I'll close by saying, now let's fast forward a little bit more into the future. And let's say all this is now happening on your face because you're walking around with some kind of mixed reality device. Maybe it's an AR type, glasses, goggles, whatever you want to call them, and it's recognizing objects constantly because the computer is trained to do that. And so as you look around, you see things, and maybe that's triggering experiences too that are either informational. Like, okay, I see a Citibank logo, and now it's going to tell me like what the hot mortgage rates are. Maybe that's not that interesting, but these things can happen. Maybe it gives you directions to you see a McDonald's logo, and then it tells you like where the closest one is and how to get there. Something that's kind of like promotional, but also informational. But then also again, like competitive type things. What if you recognize a Starbucks? Your computer recognizes a Starbucks logo. What if Pete's pops up and says, hey, go over to Pete's instead. It's around the corner. So these are interesting things that I think are in our future. And I think there's both opportunities for consumers to be more confused, depending on the paths we take, or less confused, depending on what kinds of technology we end up adopting. So I'll turn this back to the panel, but these are interesting bits of food for thought, and look forward to working through them as a group.
Thank you. Yeah, we definitely have a great group of panelists from all different perspectives. We've gotten a couple of questions that have come through, and I have a couple of my own as we move forward. Sonia, I'm going to start with you just because a couple of the questions that have come through, and one I have myself as well, is just maybe going into a little bit more detail about how AI may affect the trademark registration process or the trademark search that would be conducted. A couple of our participants, for example, are interested in knowing what percentage of trademark applications are generated by AI, if known. And my kind of follow-up to that is if we don't know this, should we be maybe updating our trademark applications or the goods and services class to more readily identify those sorts of applications that are being followed? And another participant also posed the comment about, can we use it to improve design searches by using AI enhancements and improvements, which I would be all for, because I really do not like doing design searches on my own.
Yeah, I mean, these are great questions. I don't have sort of hard statistics for you about what percentage of trademarks are driven by AI searches. I think that the best way to kind of see what's happening in the ecosystem, however, is for us to look at the landscape of kind of private organizations that have sprouted up to help trademark registrants do search, comparison, and clearance. And to see that many of these methods of search are actually optimized by AI-driven techniques. So, for example, I mean, when I think of AI in the trademark context, what I think of is the fact that AI allows us just by the sheer numerosity of data sets that can be built around trademark registration and powered through search, in very quick and incredibly efficient ways. I think that it really does allow governments and firms to be able to identify with substantial accuracy the likelihood that the mark that they're considering might be infringing on another or raise issues for clearance. So I think it speeds up the process. It also improves the accuracy of that process. And I also think that what it also does is it enables, just when we think about litigation as opposed to registration, the sheer numerosity of data sets that can be used and deployed in different ways will help us to improve the quality of trademarks. It will help us to improve the kind of quality of the arguments that surround things like substantial similarity. And so these things, I think, are things that have been percolating in the marketplace. I mean, every time we see something that is developed that's more efficient, we see different changes in the trademark kind of registration ecosystem. What I think AI does, though, is it really revolutionizes a lot of this. And it's also just important for us to point out that, this is already happening, right? Many of these engines have been using machine learning and, inputting data from case law and learning iteratively along, for a very long time. So what I'm saying is, just that these processes have existed over time, and what they do allow us to do is really optimize on the efficiency of search. I don't know if others have views about that.
Yeah, I mean, the one thing that's interesting is, at least from a trademark practitioner point of view, when we do clearance, we use something like CompuMark to do a trademark search report. Well, guess what? CompuMark uses artificial intelligence to get you those results. Like, those results are, in some cases, we'll be using humans, but the design search is already AI-based. The trademark search, they had acquired a company 3 or 4 years ago that was all about AI trademark search. And that was, long ago. So, I go back to it. I think this is Sonia's point. It's in the machine already. We've been here the whole time.
And I'll just add that from a practical perspective, I think that starting in like the spring of 2019, WIPO started offering AI-assisted design searches that you can just do by going to their website and searching the national trademark registries that they cover. And in theory, it's a lot more targeted, and you get more narrower results. And I think it's deep machine learning is the tool that they use for finding similar designs. And then, as others have said, there's a lot of vendors out there that are already doing that. I think Trademark Vision is one of them. Trademarker is another one that's trying to get away from just like the old school kind of design code type searches, which I think have a lot of subjectivity baked into them, to something that's more literal, like pixel comparisons and so forth. That in theory could be more accurate depending on how well they operate.
So just
go ahead, Anka.
Yeah, perfect. We actually in 2019 have done a bit of a test with a few of these AI tools from WIPO, from EU IPO, the Australian IP office and the Singapore office. And we've tried to test a little bit how good are these engines actually. So we've tried to see whether, for example, the legal break would be identified through these image recognitions AI tools that they have. And actually the results were still rather poor. This was in 2019. So these bricks, for example, didn't come up, only in the Australian one, if you really look at the shape mark, for example. So identifying on a registry, an online database, a particular shape seems to still be difficult. And I've been talking to some of these developers that indeed it is difficult when it is an image and you're actually only looking at part of it and identifying that. Without a doubt, this will become better. So I guess image recognition is really something that will go forward very quickly. And maybe today it's even much better than 2 years ago. I'm pretty sure about that. But we also tested 2 other things. I just want to throw that in because in trademark law for examination, for example, descriptiveness is an issue, or public morality are grounds for refusing trademarks, at least in the EU. And getting an AI to train that to do these things is very difficult. And in our test, only the Australian one is actually coupled with certain dictionaries to check the meaning and then compare that to the category of goods, whether that in somehow is descriptive. And so there we still see a lot of room for improvement.
I think the trademark practitioners among us will be happy to know we're not out of a job yet.
Josh, actually, I
Yes.
was going to come back to you with a question in line with that in terms of, do you see any distinctions in how consumers may be confused in reality versus in the augmented world? And one of our participants also asked whether or not you think AI will lead to a reduction in trademark infringement if it can be used to more easily weed out the infringers.
Well, I was thinking the same thing as Matt was talking about the augmented reality question, because again, I go back to, well, how is it done? So in his example, he was talking about Coke and Pepsi, and I was sort of wondering to myself, okay, I'm looking at a Coke, something comes up about Pepsi. If you disclose what's going on there, I don't think a consumer necessarily would be confused. On the other hand, if you are looking at something and you think there's a connection, and it's just going to be based on how the augmented reality is set up, then that could be an issue. So I go back to, I don't know that the fact that it's artificial intelligence or augmented reality is the issue. It's the how you set it up. What is the perception of the consumer? If I'm going to Starbucks and I see, hey, you seem like you want coffee, why don't you try Peet's? I'm not necessarily, at least in my head, thinking, oh, Starbucks and Peet's must be related. Instead, I think that it's identifying an interest I have and a brand that it's connected. But again, it all turns on how it's being given to you. And it's interesting because that part of it isn't really automated. That part, some designer sits there and says, this is how we're going to use it. Not to pick on Matt's company, but they get to do cool, innovative stuff. And someone is in there saying, it would be fun to have a cartoon filter. I don't think the AI came up with that idea. And so the implementation of it might have artificial intelligence, but there's still room for creativity among the humans who are saying we should do it this way or that way. And that's ultimately, to me, the answer in most of these trademark infringement issues.
Let me add one sort of real world example here. This is not my company, but it's something I read about a few years ago. And the concept is called conquest ads. And these are ads that are where you can use augmented reality to, one brand can use augmented reality to like kind of over another brand as kind of a means of comparative advertising. And the real world example is this, I think it was in Brazil, but somewhere in South America, a Burger King was doing a campaign against McDonald's. And in the Burger King app, you could use your device to have your camera recognize McDonald's menu or certain McDonald's billboards, and those were markers that the computer would recognize and then would trigger an AR experience. In this case, it would light it on fire virtually, burn down the menu or the billboard, and then reveal behind it a Burger King ad. And it's a wacky idea. It's kind of fun, But I don't think anyone's going to get confused by it, right? Because you're holding up your phone to a menu, you're holding up your phone to a billboard. I don't think that's going to be confusing. But I think fast forward to where the technology becomes more sophisticated or wearables, certainly, then I think there are going to be a lot of opportunities for confusion. But look, as Josh says, I think it's all on how it's executed, and I don't think the fact that it's AI powered matters as much as more just like the basic facts of how a consumer experiences the information.
You could imagine a situation where what that technology did was defamatory or tarnishing, and that would be a different kind of a claim. Maybe it's not trademark that does it, but let's say that it suggests something about McDonald's that was untrue, something about their food products. I don't know what the thing would be. Then I think McDonald's might have a claim. It might not be a trademark claim though. And that's the nice thing about the law is there's all kinds of different levers that still would help the brand owner in that circumstance if it was really an ad that they wanted to go after.
Right, including issues of unfair competition, maybe. Another participant posed a question as well in terms of just trying to find consistency maybe in the law with respect to trademarks and dilution and whatnot. And Anka, I'd be interested in hearing from you more about the consumer perspective. And then I'm going to give you a heads up, Matt, because I'm going to come your way about that same thing. Because you mentioned something earlier that I think is really interesting about the necessity of brands in this new AI world and potentially how we may order things as well. So Anka, can you speak a little bit more about the consumer buying process and how AI and trademarks kind of intersect with that?
Yeah, sure. I mean, again, I've looked at a few different tools of AIs that are used in online shopping. So I've tried to identify a little bit how that works. I'm not in the business myself, so it's sometimes difficult to get the information really to know what they are doing. But yeah, policy recommendations are something similar. We've just talked about that in augmented realities. You are offered with different choices, and the consumer needs to be wary of what is happening there. And at least in EU law, from the keyword advertising case law, the CJEU is willing to look at the internet user who is supposedly reasonably aware of what is going on. And as long as these recommendations, for example, are offered as alternatives and not as imitations, and there is no harm being done to the other trademark, and that is what I wanted to add to Matt's and Joshua's idea of the other logo being burned down. If there is some harm, the court, at least in these situations, may come to the conclusion that there is harm to the reputation. And I think it matters indeed a lot how these product recommendations are being offered. If it's clear to the consumer that these are choices from which he needs to choose, which to a certain extent, people that learn how to use these will be probably able to distinguish that. But that is, I think, also the question of some empirical work that we need regarding this behavior, and so that judges can possibly then make a better choice in whether at that moment there is confusion or not. And the other tools that I've looked at are really then more automatic ordering or virtual assistants, where there is very little involvement by the consumer. And so there I'm very insecure at this point to make any predictions because I don't know whether there is enough trust among consumers right now to just accept these choices that are offered to me by the AI virtual assistant, and without checking and without really going into it, just would order it. So I think there we need indeed more legislation also about the transparency of the AI tool that is behind it, that gives us the information like which types of biases could there be, what would be the data. And I guess that's very difficult because I really have also difficulties understanding much of that, and so normal consumers may have the same. So I wonder where that can go. I don't know whether there are more ideas about that, but I guess we need more transparency about the AI tools that help to make these suggestions.
Right. I am afraid, Anka, I am afraid. That's a 2001 Space Odyssey reference there for you, Matt. So coming back your way, and in line with that, I think this is something that you had mentioned earlier when we spoke too about, are brands even necessary in the home buying online process world, where we're really identifying more of the quality or feature or functions of goods that we want and not necessarily identifying them by brands?
Yeah, no, I think this is a great question. And I think that brands at the end of the day are shortcuts, right? They tell you a little bit about quality. They tell you a little bit about characteristics, perhaps of the company that's offering it. And there's also just sort of a intangible feel about a particular brand that may be attractive or unattractive to the purchaser. And I think that these intangibles, I mean, brands are emotional things, right? I mean, they are designed to appeal to our emotions generally, and AI is going to change that, at least to the extent that the consumer is delegating to their computer, their whatever, their device to make decisions for them about certain kinds of purchases. So, right now we already have things like subscribe and save on Amazon, where you can get your shampoo, every 2 months or whatever. And you may have it set to buy a particular brand, in which case that is going to, lock in that brand as far as, that purchase, not just this time, but probably for the next while, assuming that the consumer is not going to be tinkering with their directions to the computer every time. And that kind of cementing in can, I think, really help a brand and lead to like a stronger relationship. It could also lead to brand complacency if they feel like, okay, we're locked in, we have X number of million people are automatically buying our stuff, every week or every month. Now we don't really have to advertise as much, or we don't have to compete as hard, or whatever. I think that would be interesting to see. But you can also have, as you suggested, brands not really participating in or being a part of the decision. I mean, if you're instructing your computer to buy your shampoo based on price, or based on how like green it is, or how quickly it can be shipped, or whatever, like these like other things are not really brand dependent, and may lead you to get all kinds of different brands coming in the door. And if you don't care and you don't update your preferences to reflect a brand, then basically the AI is making decisions based on things like price and these other attributes. I mean, we already do that as consumers anyway, right? Like we're already not just blindly following brands, but our brands are, represent other things to us, including price or other attributes. So I think it's separating the human from the machine in terms of like that purchasing decision. But in a kind of a set it and forget it kind of world, I think brands, depending on how people have set it, it can be very pro brand. Locking you in long-term with a relationship with a brand, or it can be very brand agnostic, in which case brands will have to get a lot more creative or try harder to break into whatever algorithm that you've set so that you will buy their products.
Could I jump in for a moment? Because I think what Matt is saying is actually underscoring the importance of some of the questions that have come up with respect to algorithmic transparency. I think one of the things that's really exciting about the world that Matt promises us is a world where the consumer can make certain choices about what variables are most important to them in shopping and in purchasing online. The danger that I see is actually the danger of kind of hidden sponsorship, right? That is to say, that the consumer may think that they're getting suggestions or recommendations that are driven by their desire for a certain kind of information, but maybe what they're getting is, a subtle kind of sponsorship. And I think that's where, to me, when I think about this new era of consumer-focused AI should be moving, I think it actually just circulates around this notion of disclosure, like how much information do we owe the consumer? And at present, the consumer doesn't know as effectively as they could when things are sponsored and when they aren't. And I think that really, cuts at the heart of the effectiveness of AI.
Let me do you one better, which is, what about when the products you're offered are being determined by the artificial intelligence, not what's offered to you, what products are being created? Because one of the stories we've seen is Amazon has lots of information about purchasing, and their artificial intelligence can tell you, this is what we as Amazon brand should be making because people really love these and here are the characteristics for them. And what happens there is you then lessen consumer choice, because that's going to be the brand that gets promoted by Amazon. It's also the one that people are more likely to come across for whatever way. And then it makes it harder for brands to compete. So that's a whole other question. Again, I go back to trademark's not the only issue. Antitrust is a whole other, can of worms about, is that an anti-competitive problem or not? And I think there are other scholars who knew more about that than I do.
No, I love this. This is making me want to cancel my Prime membership, but my kids would kill me.
Well, that almost reminds me too, when you talk about the subtle feature sometimes of trademarks and how we might experience that in an augmented reality. I mean, I'm at the point now where when a Target commercial comes on, I know immediately it's a Target commercial just because, one, of the color red, but then also just the overall feel of it. If I'm in an augmented reality, I may not see like a Target sign, but that they may buy into it with a certain color red, or John Deere is on my brain now too because they're in the news, but that certain color scheme. And how might, you talk about transparency, how may that affect the consumer, and how transparent should these companies be when they are allowing these subtle influences to come into play?
Let me just chime in with a few thoughts there. And first of all, I want to just offer disclosure, which is that this future, this dystopian future that we're talking about in some respects is not going to be brought to you by Snapchat. We're not that kind of company. But just sitting in this seat and looking around, I definitely see little bits and pieces coming together about the ecosystem that we're going to all be participating in as consumers in the future. And so I think there are some good analogies that already exist right now. I mean, search is a great one, right? And we've had Google search for a long time. And I think we as consumers can distinguish between natural search and sponsored search results when we plug something into Google. I also think that the FTC, has some rules about what can be, like kind of like the advertising that you would get in like a product placement kind of example, or an influencer type thing where there has to be that ad slug, as we call it, somewhere disclosed somewhere, right? Now, I think it can get more nefarious than this without a doubt, and maybe it already is, frankly. I mean, we've already talked about these examples where you can't really distinguish between true search results maybe and ones that are influenced by paid actors. But I think that the basic framework probably already exists within, between like FTC type rules and other in just, judicial precedent. But I think it's gonna have to adapt. And I think that, looking far into the future with like the wearable that we are speculating about, there could be some serious opportunities for confusion, like intentional confusion, right? And I think like both the companies that are offering those products need to be thinking about that, and certainly our regulators need to as well. But I will say one thing though, is that if it's a platform like an advertising type platform that's offering it, or it's a platform that has an advertising component in it, Google being the best example. If you're doing something that is really anti-brand owner, right, then it's going to be bad for their business too. So on some level, I think there's going to be a move toward kind of like a sort of almost like a free market type reaction where like a company is not going to want to do anything that's too anti-brand owner or favoring certain brand owners over others necessarily, because it'll just turn off those others who will not want to participate in the platform. And so I think to have a healthy ad platform like Google, you want to have one that it like has fairly ground rules, like fair ground rules that apply to most people that people can feel good about, participating in. And I'd like to think that will be a forcing function, even if, our regulators are slow to catch up to the reality that's coming.
I'm so glad you mentioned the FTC, because they sent 700 letters yesterday to a variety of brands on those endorsement guidelines. And so you would think, to the extent that they are paying attention, that that's an area they'd look at. One concern I have, though, with the sort of free market approach is you end up, instead of in a keyword advertising scenario, you end up in a GTLD scenario where there was that, they opened up all these top level domain names and said, hey, brands, you better go buy these for, a lot of money, because otherwise someone else will snap them up. And that created this whole gold rush or land rush for them. Which was, although even playing field was, I have a lot of brand clients who were not happy about sort of being forced into that scenario of either buy this for a lot of money or, hope for the best.
Yeah, no, that's a great analogy. I think what I would respond to for that would be, at the end of the day, just think about the incentives that the wearable company or the platform that powers the wearable has, which is to be a enjoyable experience for people. And so if you're walking around and you're just being bombarded with confusing augmented reality or mixed reality type information that is, I mean, you think of like Minority Report or, the Blade Runner movies, like, I mean, no one wants that, right? Like, you're going to take off the glasses or you're going to throw them in the trash if they're that annoying. So I think the companies they're going to have to be careful about letting things get out of hand. So even if the FTC or whoever is slow to catch up with regulating this space, I think the companies are in their own self-interest are going to make it so that consumers have a reliably, I think, fair and transparent experience. But I know others have been, again, we've been talking a little bit about transparency in algorithms And I just want to say that that is something that is incredibly important, is reducing bias in artificial intelligence. I think that the trick is really about having good quality training materials. Like the biases tend to come from the training materials in the first place. So for example, and this isn't, we're a little bit off course here because it's not really a trademark issue, but if you're going to train a model to recognize faces and you're only using faces that reflect a particular look or race or gender or whatever, then your outputs are going to reflect those biases. And so I think it's incumbent on anyone who's in this space to make sure that they are using diverse inputs so that the outputs can be realistic and not skewed. And I can say that this is something that Snap takes very seriously.
Thank you for that. I'm going to pause briefly so that I can read off the CLE code for this panel. So the CLE code for panel 5 is R2D2. Disney is a sustaining sponsor, so I think that they're okay with that code. It's R2D2, that's R as in Romeo, the number 2, D as in Delta, the number 2, R2D2, Romeo 2, Delta 2. And I'll take a moment here to thank Kirkland and Ellis for also being a sponsor and my former employer, Barnes and Thornburg. So thank you to all of our sponsors. All right, so back to our panel discussion. Maybe with the little bit of time that we have remaining, unless we get some other questions in from the participants, I would be interested in knowing, can you just give me maybe the one thing that is coming down the pipeline that you would like to see happen with AI and its implications with trademark law, or the one thing that concerns you with the implications of AI and trademark law? I'm going to pick on you, Anka, because I haven't heard from you in a while.
Sure. So I think for me, what I see as definitely a development that we need to look at is if we are using AI technology to also perform some of the examination of trademarks when we get them to the offices. That Sonia already talked a little bit about that, about the search functionalities and how AI can help there. And I mean, the state of the art right now, but again, I'm not a developer or someone who knows these AI technologies in that detail. But what I see is that we are really at this point still not at the point where they are actually performing tests that go further than only necessarily the search functionality, the image recognition, but where really also questions of likelihood of confusion, or because it's not only if the similar goods are having similar signs, then there is a likelihood of confusion. That's sometimes what I saw in the private Trademark Now, for example, these risk assessment when you are looking at enforcement of these trademarks as well. That risk assessment is really just based on a very simple assessment of similarity of goods and similarity of signs, but we need actually more factors, at least in EU law. It depends also on the circumstances, on whether these goods or services are really similar. That's, at least from what I saw, still very difficult to assess. So I'm pleading a bit of a caution as to what AI can actually do in trademark law when we are looking at real assessment, because trademark law depends a lot on the perception of the consumer, which is a human in the end, if we are still involved in purchasing. And that is, at least at the moment, I think, in the end, and I think this last stage of consuming the product will stay like that, and we are prone to perceive trademarks in the way we've always done so. So I think there is some caution as to what AI can really contribute. So yeah, I'm just pleading for that to be one of the ways to look at it as well.
Yeah, I'll just follow up by saying, you know, I agree with everything that Anka has said. I guess for me, I'm just going to, you know, this is an obvious point, but I feel like it is really, really important to say is, you know, the advent of AI in our legal system is, you know, of huge sort of surprising level of potential for litigators planning their cases, planning pleadings, and so on. I think it's really important for us to to really sign on to the idea that AI in all of these different elements just needs to aid human judgment. It cannot be a substitute for human judgment. And, I have lots of questions and discomfort with the discretion of judges. But I will say, kind of following Matt's points about bias, I have a little bit more discomfort with the idea of automating judgment. And I would say that for trademark law as well as kind of every other area of law, that I think AI can help us optimize our results, but I think our results have to be driven by humans. I will just say, as a dystopian fact, the point that I made about sponsorship and the FTC's kind of shallow wading into the regulation of influencers is, only just kind of a drop in the well of the kind of disclosure that I think is really important for individuals to receive when they're shopping, listening to music, surfing the web, whatever. I think that there's different levels of disclosure that also need to be explored.
I would just end where I started, which is I'm concerned in litigation that AI will be something that people will incant and then say, it's AI, therefore, old rules should not apply. This is a whole new thing, therefore, I'm either not liable or I am liable or, whatever. And I always, feel that we need to go back to, sort of basic principles. We have cases and we have laws that do give us some sense of where the law is going to develop here. And so, as we've litigated cases, courts have been very comfortable with the idea of, okay, this may be the first time I'm seeing this particular fact pattern, but I've got some, case law to look to and some basis for it. Especially with trademarks, a lot of that is so much based around consumer perception that the facts really will, I think, be determinative. And so that'll be, I think, where the trademark AI cases are going to go is, seeing how people are using it and what do consumers understand when they're encountering trademarks or other AI use.
I'll chime in and say that I think one thing that concerns me, but I also think will be interesting to see how it plays out, because I think it's already playing out in sort of a basic human way right now, is on Amazon. And you read these articles about the proliferation of brands on Amazon, not major brands, but like little made up brands that are designed just for Amazon. And in fact, there are companies that, usually smallish manufacturers in China that may offer shoes or shirts or whatever, but they will have multiple storefronts with all under multiple brands, but all selling the exact same goods, and tweaking the brands and creating new ones all the time in order to appeal to people in one way or another. And so if you take that to the next, like the next level and say, like, well, what if you do that in a more sophisticated way? What if you actually craft brands that are meant to appeal not just to a basic search result type experience, which we as people will type in when we're looking for something on Amazon, but rather crafting brands that will appeal to AI that's actually doing the searches, for you, if that's something you've delegated to your account. And so, and if you want to be cynical or nefarious, where you can think also about, well, what if you were to craft a brand that is calculated to confuse an AI type search, so that the consumer buys, the quote wrong product, but that it's done in a way that exploits flaws within the AI, but that might not be noticeable if you were to print it out and put it on a piece of paper and ask a jury to look at it or a survey respondent. And so, is there a world where people intentionally create brands that are meant to confuse AI, but that don't confuse the mechanisms we have in place to determine confusion, like survey experts or juries? So it's just something to throw out there, kind of strange thing to think about. I don't think it'll be a huge deal, but my guess is it'll happen.
Amanda.
Yes, go ahead, Anka.
Can I ask something? Because I think Sonia's point about disclosure is a really important one. And I'm just giving this some thought, and I'm thinking, what type of information would we really need, and how can we give this to consumers so that they know more about how they are assisted by the AI and on which basis it functions, because machine learning is very difficult, I think, to explain what exactly goes in there. And mentioned also that maybe sponsorship may play a role in the product suggestions that come out, but it may also play a role like who you are, of course, your gender, with which type of computer are you logging into the system. And I mean, there may be quite a lot of factors. So the question really is, how can we provide such transparency to consumers that it is helpful and that it is possible to explain? I don't know whether anyone has thoughts on this, but this triggered me.
I do not have thoughts on it because I think if I have too many thoughts on it, it will concern me. But it is definitely something that I do think needs to be addressed. And I will throw that back to CPIP as maybe next year's conference idea, just all about transparency in the law and intellectual property. Well, I want to thank all of our panelists. Sonia, did you want to add something?
No, I just want to say, Anka, that is like the question of the hour. And yeah, hopefully we can all assemble here next year and have better answers to this really tough question.
Fantastic.
An election year is coming up. That's my answer. Election year is coming up. Be mindful in who you vote for. So thank you again to all of our panelists and for joining us today. If you missed the conference code, it is posted in the chat, and I will also read it aloud again. That is R2D2. That's Romeo 2, Delta 2, R2D2. And as a group of trademark expert and panelists, I would be remiss if I didn't remind you to please go check your brochure for all of our lovely sponsors and their branding and logos. So thank you all for your sponsorship. And at our next session, we're going to take a bit of a break from 3 to 3:20. So panel 6 will start promptly at 3:20, and it is about tech policy in artificial intelligence. So I hope that you will come back and join us then. Thank you, everyone. Applause, applause, applause.